Hello, dear viewers. The lesson of today is Feminist Jurisprudence. The legal profession in all branches was, until recently, dominated by men. Harvard Law School did not admit women as students until the 1950s. And the first female United States Supreme Court justice was not appointed until 1981. As a result of the paucity of women in influential positions in the profession and the generally subordinate role of women in the society, the law failed to reflect women's interests concerning and their perspectives on a wide range of issues. These issues included the rules of evidence in trials for rape, the sale and display of pornography, sexual harassment in the workplace, gender discrimination in employment and education, rules governing divorce and child custody, legal restrictions on abortion, and workplace accommodations to pregnancy. Beginning in the 1970s, feminist lawyers such as Ruth Bader Ginsburg and Catherine McKinnon began, through their teaching, writing and litigation and other professional activities, to achieve significant reforms in the legal treatment of women. The theoretical branch of the women's law reform movement is known as feminist jurisprudence. Origins of feminist jurisprudence. Its origins can be explained in a number of ways. One sees it as offshoot of critical legal studies. Many feminist legal theorists subscribed to the early principles of the CLS movement in the 1970s, including the basic critique of the inherent logic of the law, the indeterminacy and manipulability of doctrine, the role of law in legitimating particular social relations, the illegitimate hierarchies created by law and legal institutions. In 1983, the CLS conference devoted a section of the conference to feminism specifically. A caucus of femcrits emerged. Some of the earlier work on feminist jurisprudence reflects this. McKinnon's comparison of sexism to classism and feminism to Marxism, Olson's work on the family and the market, Rifkin's analysis of the law's relationship to oppression, in particular to patriarchy. Feminist jurisprudence is also necessarily a development from the women's movement more generally. This emerged in late 1960s and early 1970s with the writings of many scholars. The development of feminist jurisprudence on the heels of feminist sociology, feminist philosophy, and feminist history was a natural extension of the engagement of female reflection and speech to one more area of discourse. There was a large proliferation in the 1970s and 1980s in women's studies courses. The large number of women studying law, a phenomenon of the late 1960s onwards, also had its impact, as female students began to question a curriculum which neglected issues of central concern to women, such as rape, domestic violence, reproduction, unequal pay, sex discrimination, sexual harassment. Most of the leading writers in feminist jurisprudence were law graduates. Some who became practicing lawyers undertook litigation on behalf of women, and this litigation nourished both their scholarship and others. The term feminist jurisprudence was first used by Anne C. Scales at a Harvard conference in 1978. Her article, Towards a Feminist Jurisprudence, was published in 1981. Catherine McKinnon's influential article, Feminism, Marxism, Method and the State, Toward Feminist Jurisprudence, first appeared in 1983. Feminist jurisprudence is a house with many rooms. In this, it reflects the different movements in feminist thought. But what unites feminist legal theorists is a belief that society and necessarily legal order is patriarchal. It seeks to analyze the contribution of law in constructing, maintaining, reinforcing, and perpetuating patriarchy, and it looks at ways in which this patriarchy can be undermined and ultimately eliminated. This is one of the things that clearly demarcates feminist jurisprudence from mainstream legal theory. The inquiries of feminist jurisprudence. Like CLS, feminist jurisprudence inquires into the politics of law, but its particular focus is on the law's role in perpetuating patriarchal hegemony. There is a useful list of feminist inquiry into law in an essay by Heather Wishick. She suggests 7 questions that feminist jurisprudence poses. They are: what have been and what are now all women's experiences of the life situation addressed by the doctrine, process, or area of law under examination? Number 2. What assumptions, descriptions, assertions, and definitions of experience, male, female, or ostensibly gender neutral, does the law make in this area? Question number 3. What is the area of mismatch, distortion, or denial created by the differences between women's life experiences and the law's assumptions or imposed structures? Question number 4. What patriarchal interests are served by the mismatch? 5. What reforms have been proposed in this area of law or women's life situation? How will these reform proposals, if adopted, affect women both practically and ideologically? Number 6. In an ideal world, what would this woman's life situation look like? And what relationship, if any, would the law have to this future life situation? Question number 7. How do we get there from here? Feminism, feminist, and feminist legal theory. Feminism is an awareness of women's oppression and exploitation in society, at work and within the family, and conscious action by women and men to change this situation. Anyone who recognizes the existence of sexism, that is, discrimination on the basis of the gender, male domination and patriarchy, and who takes action against it, is feminist. Feminist legal theory is concerned with how the law affects women. The inquiry of feminists is asking the woman question, which in law means examining how the law fails to take into account the experiences and values that seem more typical of women than of men, or how the existing legal standards and concepts might disadvantage the woman. Doing law as a feminist means looking beneath the surface of law to identify gender implications of rules and the assumptions underlying them, and insisting upon application of rules that do not perpetuate women's subordination. Why do feminists need a theory? Theory is required to understand the nature of many of the problems the women face in confronting the law. Theory as a process of abstraction and generalization is not a luxury for feminists engaged in using the law to bring about social change. Theory grows out of the direct experience and consciousness and is thus useful to understand the similarities and differences among the concrete situations. Theory expresses and grows out of experience, but it also relates back to that experience for further refinement or modification. No single feminist theory is complete. There are three main approaches: radical, liberal, and socialist, which differ in their understanding of the nature of women's oppression, the role of law in that oppression, and the strategies for overcoming that oppression. The three main approaches of feminists: liberal, radical, and socialist. The women's movement all over the world offers a wide-ranging feminist critique of society. Both the early and contemporary feminists are engaged in a fundamental re-examination of the role of women in all spheres of life and of the relationship of men and women in social, political, economic, and cultural institutions. Both have defined women as oppressed group and have traced the origin of women's subjugation to male-dominated social institutions and value systems. But there is a difference in the analysis of the origin of subordinate status of women, the persisting lower status, and what strategies are to be adopted and devised to end this subordination. This difference has given rise to three major ideological movements. They are liberal feminism, radical feminism, and socialist feminism. Liberal feminism. The historical origin of contemporary liberal feminism goes back to the 18th century. Mary Wollstonecraft, William Thompson, and John Stuart Mill are well-known liberal feminists for their ardent support for women's causes. Amongst the first systematic and serious works on the subject is A Vindication of the Rights of Women, published by Mary Wollstonecraft in 1792. The main idea of the work was that women are first and foremost human beings and not sexual beings. They are rational creatures capable of governing themselves by reason. Hence, if women are denied natural rights, it must be proved that they have no rational capacity. John Stuart Mill, an ardent supporter of women's cause, in his work The Subjection of Women, argued the existing relations between the sexes, the legal subordination of one sex to the other, is wrong in itself, and now one of the chief hindrances to human improvement, and that it ought to be replaced by perfect equality, admitting no power or privilege on the one side nor disability on the other. An early theme and pursuit for feminist thinkers about law was equality. For liberals, equality amounts to equal opportunity. Liberal feminists such as Ginsburg primarily seek equal treatment of women and men. Liberal feminism did not provide more insights into the roots of women's subordinate status. The sex role differences are accepted, but with a proviso that both are considered equal. Hence, women should have civil rights such as right to vote, right to education, etc. The liberals started to enlarge the concept of equality beyond the formal equality in civil and political spheres to child care facilities, the rights of poor women, and women's control over their reproductive life. They advocated improvement in social customs, institutions, laws, and attitudes while accepting the existing social structure. They further advocated that women must be free from all outward control of any sort, either of their families, which are patriarchal in nature, or of the state itself, as some bars were imposed on women in public employments. Radical feminism. Radical feminists such as Littleton and McKinnon focus on differences between women and men and support affirmative measures to challenge inequalities. Radical feminists are pessimistic about meliorist reforms. McKinnon, the pioneer of radical feminist jurisprudence and virtually the inventor of the concept of workplace sexual harassment as a legal wrong, analogizes women to the proletariat in Marxian analysis. The premise from which the radical feminists proceeded was that the roots of subjugation lie in the biological family. The hierarchical sexual division of society and sex roles themselves are the factors which must be basically recognized if true gender equality has to be established. The proponents of radical feminism contended that the biological destination is used to distinguish social functions and power. Biological differences result in the male domination of power over women. Patriarchy is identified by the radical feminists as an autonomous historical fact more rooted in biology than in economy, and they consider gender relations to be the primary form of oppression. Radical feminists have also contended that the patriarchal system is preserved via marriage and family through sexual division of labor in society. It manifests itself in different forms, but in all such forms, the avenues of power are in the hands of male. The radical feminists assert that though there is no reason why reproduction and socialization should occur in family, the basic pattern has been there in historical societies. Thus, the nuclear family is considered to be an impediment in the full realization of equality. This contention differentiates them from liberal feminists. The main assertion of radical feminists has been not only removal of all sex distinctions, but also that there being no place for men in their lives. Man was considered as an enemy and subordination was seen as biopsychological supremacy of male over female. The radical feminists believed in sexual preference, control over one's body, free sex and collective child care. According to them, masculine hostility manifests itself through rape, pornography and sexual violence. The overthrow of male dominance requires a complete sexual revolution which would destroy traditional sex taboos. Through consciousness raising, women should be made aware of this dominance, solidarity among them to be developed, and they should be made self-reliant so that they are not dependent on men in any sense. Socialist feminism. The chief architects of socialist feminism are Karl Marx and Friedrich Engels. According to the socialist view, women's inferior status is rooted in private property and class-divided society. For the socialist feminists, it is imperative to understand the operation of hierarchical sexual ordering of society within the class structure. They also feel that overthrow of the capitalist system by itself will not mean transformation of patriarchal ideology. It would be necessary to organize struggles against capitalism and patriarchy. Socialist feminists, as the radical feminists thought, are of the view that family was an institution which reinforced women's oppressive condition. Family and economy should not be looked upon as separate systems, but as vitally interacting systems. The unequal and hierarchical sex role operate in both the domains of family and economy. The orthodox Marxist analysis considered housework as producing only use value but not exchange value. A group of socialist feminists argued that women's oppression is based on unpaid housework. Socialist feminists do believe that women's issues are specific. They need focused analysis and attention. Hence, women's groups have to be independently organized, but they cannot ignore the other struggles against oppression and exploitation. Thus, feminism is an awareness of women's oppression and exploitation in society, at work and within the family, and conscious action by women and men to change this situation. Today, feminists have gone beyond the mere legal reforms to end discrimination. They are working towards the emancipation of the women. The present-day feminism is a struggle for the achievement of women's equality, dignity, and freedom of choice to control their lives and bodies within and outside home. Feminist view on the relation between women and law. Notwithstanding diversities of feminist thinking, feminist legal theory shares some basic assumptions. Feminist legal theory can be seen to be concerned with addressing two questions. How does the law affect women and contribute to their oppression? How can the law be used, if at all, to improve the social position of women? The first question, how does the law affect women and contribute to their oppression? Feminist legal theory might be seen to begin with an analysis of discriminatory rules and social practices and the reasons underlying differential or discriminatory treatment. Since such differential treatment is often defended on grounds that it protects women, both the rationale and the effect of law have to be examined to determine whether rules or practices advantage or disadvantage women. Many feminists have argued that the methodology of legal reasoning is patriarchal and based on male moral reasoning. Feminists argued that women approach moral reasoning differently than men, that women are more sensitive to the context and experience and less inclined to generalization and abstraction. Further, the emphasis on principles and precedents in traditional legal methodology has been argued to be inherently conservative. Its backward-looking focus serves to perpetuate the male bias and the exclusion of women's experiences from the law. A related level of analysis might be seen to be the feminist challenge to law's epistemological claims to neutrality. It questions laws and practices in fundamental ways, as well as the reasoning process by which we understand and apply them. The existing system does not embody women's perspectives. Radical feminists such as McKinnon argued that the law's objectivity is male subjectivity. Thus, feminist approach to law can be seen to start from a basic assumption about the relationship between women and law, that the law is informed by and serves to reinforce the patriarchal social relationship, that it is based on male norms, male experience, and male dominance, that women's experience is excluded from the law, and that the law has contributed to women's oppression. The second question, how can the law be used, if at all, to improve the social position of women? Some feminist jurists have taken the view that the law reform is not an appropriate measure of dealing with discrimination against women. Their contention is as follows. Limited changes that law reform can introduce and the relation of the law to the rest of the society is very low. If legal rights are restricted to granting formal equality to women, they will not be of much use to them whose access to the legal system is very limited. It is claimed that to be meaningful, the laws should ensure substantive equality. Laws as enacted and implemented by the state agencies are biased against women. The liberal feminists' effort to make the state responsible for welfare services as the means of ensuring substantive equality to women attract the charge that these measures will strengthen the hold of the state on women. Other feminists, especially liberal feminists, argue in favor of the law reforms to improve women's social position. They subscribe the view that law plays an important role in defining relations between men and women, and it is worthwhile to explore possibilities of it changing the existing notions of rights of men and women. Law protects the powerless, not by removing the sources of power over them, but by directing this power to some extent into relatively predictable forms, by imposing conditions on its use. Further, law itself is a form of exercise of power, and women can use this power themselves. Law can effect a gradual change in social attitudes. Law can function as a persuasive form, that is, rather than prohibiting certain behavior, law may permit certain behavior. Law can serve a symbolic function and thus create conditions which are conducive to social change. Therefore, instead of dismissing law reform as a means of achieving equality for women, it is more productive to realize the limitations of law. It is important to work towards reforming the discriminatory aspects of law than to dismiss the law reform. The argument that the legal rights are only marginally useful because very few women can enforce them is not necessarily a valid reason for not reforming the law. On the contrary, there should be an argument for increasing women's access to the legal system. Moreover, measures to introduce legal equality are directly relevant and useful to those women who do not have access to the legal system. Feminist legal methods. Feminist theory challenges the positivist empirical tradition, the assumption that through observation and measurement by an objective observer, the truth about reality will emerge. Feminist legal methods, by contrast, are influenced by the interpretive or hermeneutic tradition and by the methods of critical theory. Nielsen explains the differences thus. The positivist's goal is to predict and control. The hermeneutics is to understand, and critical theory's approach is to emancipate. That is, to uncover aspects of society, especially ideologies, that maintain the status quo by restricting or limiting different groups' access to the means of gaining knowledge. Though feminism and critical legal studies are two entirely different creatures, critical legal studies contribute a useful method to the feminist approach in legal theory. In feminist legal methods, Catherine Bartlett seeks to identify the methods that make the study and practice of law characteristically feminist. She emphasizes three basic elements: asking the woman question, feminist practical reasoning, and consciousness raising. These methods, she shows, reveal things that traditional legal methods ignore. Asking the woman question, meaning the extent of the presence and recognition of women's experience in law. Feminist practical reasoning, meaning a reasoning which proceeds from context and values difference and the experience of the unempowered. and consciousness raising, meaning an exploration of the collective experience of women through a sharing of individual experiences. Upon these bases, feminist legal theory seeks to articulate women's perspective upon law and thereby to empower women in the future development or redevelopment of law. In this lesson, an attempt has been made to explain the nature and development of feminist jurisprudence, its distinguishing characteristics, and its significance in the mainstream legal theory. Thank you.